My client received a letter from the school requiring the minor to go back home, that is Kibet Moi, to go back home because the child has not complied in payment of school fees. Can we really fault the school for sending the child home? Absolutely not. The choice of school was of the parents, and the court in this case gave clear orders, crystal clear orders for compliance. I advised my client in the best interest of the minor to allow the minor to continue schooling in her present school to avoid disrupting her academic schedule. Thereafter, Your Honor, we took out a notice to show cause as against the judgment debtor. We served my colleague, but she did not appear in court. Consequently, the court issued warrants of arrest against the JD. Your Honor, I've had submissions by my colleague, and I wish to substantiate the same, Your Honor, as follows. Your Honor, my colleague has mentioned to court that she visited Kabarak schools yesterday and sought audience with the VC, that the same did not bear fruit. It is not shocking on us that did not bear fruit, because the person that was supposed to have initiated such kind of communication is the defendant himself. And Your Honor, you gave the defendant ample time from 13th of February 2025 to ensure that the minors are settled in school, and even gave specific timelines. That counsel was trying to visit the school yesterday goes to speak towards a defendant and a father that lacks the best interest of his biological children. Your Honor, the best inheritance that the defendant can give his children is education. From the time the court delivered itself in the judgment in 2022, up to now, the defendant has never shown any effort and or commitment to ensure that his children are properly taken care of. Yet, Your Honor, from 2022 up to now, the same grounds that the defendant has given, time in, time out, continue being rehashed before these honorable courts. That bespeaks, Your Honor, of a party or a father that is evasive of his parental responsibility as far as his children are concerned. Your Honor, the guiding principle in a children's court is the best interest of the minors. It goes without saying that the history of this matter speaks very loudly against that very interest that is enshrined under the Constitution and the Children's Act. Your Honor, I will pray that in view of the fact that there is no merited ground that has been given by the defendant's counsel to persuade this court otherwise, I will pray that the defendant be committed to civil jail for a period of 1 month. Perhaps within that time, the defendant will have a meeting of the mind with himself to realize that the proceedings that are before courts are not about him and the mother of these children, but about the best interests of the minors herein. He will forever remain to be their father, and as such, under the Constitution and the Children's Act, he is bound to ensure their best interests.
I allow the judgment debtor's request to summon the members of the Kabarak trustees to shed light on the compliance of the court's directive to facilitate the enrollment of the minor to Kabarak group of schools. Summons shall issue forthwith for their attendance to court on the 23rd of July 2025, which summon shall be served by the defendant's counsel. In the meantime, I commit the judgment debtor to civil jail for a period of 2 weeks for clarity until the 23rd of July 2025. The decree holder shall pay his subsistence for the period. That is the ruling of this court.